Hi, everybody. It's Diane Neto living in Barrie. I want to talk about a very common misconception in real estate. I remember my very first day at property law. A lawyer was actually teaching the class, and the first thing he said was, the largest misconception is if I'm a common law spouse, I'm entitled to half the property. And that's just not true. Not true. So if you like my stuff, hit the like, hit the subscribe, drop me a comment if there's something you'd like me to talk about. But I'm going to share the screen with you here and explain a little bit about it. So in Ontario, common law spouses do not have the same property rights as married couples. Unlike married couples who have certain protections under Ontario's Family Law Act when they separate, common law spouses do not generally have property rights on separation. Instead, general property laws apply. So, common law spouses are entitled only to whatever they brought into or acquired during the relationship. If the couple ends the relationship, there is no automatic right to divide or share the value of the property. What this is kind of saying is, in Ontario, property acquired during a marriage must be split equally, and this is acquired during a marriage, must be split equally when a marriage ends for any reason. This could include your home, your car, your business, your furniture, your pension, and money. For property that you own before the marriage, any increase in value is usually divided equally. This applies to the family home where you lived with your spouse. Okay, so let me explain to people. So I own my house on my own, okay, right now. Somebody moves in here, we get married. So say my husband moves in 2024. So I'm going to do the math for you. So he moves in 2024, and the value right now is $850. Okay. So I've lived in here 5 years. All of that equity within that 5 years is still mine. He would only be entitled to half of the equity after he moved in. So say he lived here for 2 years. 2026, I kick his butt out the door. I'm done. And the property is now worth $950. Okay. This is married. This is even married with shared assets. As a common law, you would be entitled to nothing. It's not a shared asset. And as a common law spouse, you're not entitled to something that they have their name on unless you took them to court and fought for it. Unless you put money in, you'd have to prove it. Like, it's a thing. If your name is on title of the house, it doesn't matter whether you're married or not. Okay. So even as a married couple, there was $100,000 in equity, meaning that's how much the house went up since he moved into it. So he would be entitled to $50,000. So I would have to pay him out $50,000. If it was common law and he just lived here and his name wasn't on title and we weren't married, I don't have to give him anything. So this is a huge misconception that people think that when they're living with somebody, that they're entitled to half of everything they own. They don't. It's also a huge misconception that when people get married, I'm now entitled to half your house. You're not. If somebody owned that asset before you got married, you're only entitled to the equity increase during the marriage. That's all. So I hope this explains things for people. I've done a lot of deals with people that are either common law or divorcing, and everybody thinks the wrong thing, like everybody. So I just wanted to kind of educate people on that and clear it up. And hopefully this helps if you're in that situation.